is, this is our second CLE. We are delighted to have you. As we said, it's
I'm coming, huh?
we've got our same
Peter, you're muted.
We lost you, Peter.
got you now. If you're attending the Georgia Bar's annual meeting, please be sure to come and join the reception that we're going to have. It's a joint reception with the construction law section. I'm going to turn it over to Anna Parks at this time.
Hi, everyone. Thanks for joining today. This is our second installation of a three-part CLE series, and we're lucky to have Buford Pollitt with us again today. Just a brief introduction that may be redundant if you were here last time. Buford Pollitt is a professor of energy law and commerce at the University of Tulsa. Buford obtained both bachelor's and master's degrees in geology from the University of Georgia, a master in international business management from Pepperdine, and his JD from Loyola University in New Orleans. He's a licensed attorney in Oklahoma, Texas, Louisiana, and Georgia, and is licensed as a geoscientist in Texas and a proctor in maritime law. His areas of expertise include alternative energy, carbon management, gas, geothermal, hydrogen, oil, solar, wind, and renewable energy, just to name a few. We are lucky to have Buford here today to present on solar energy in Georgia. With that said, I'll hand things over to Buford. Thanks, everyone.
Thank you, Anna. And can you hear me all right? Just to make sure before we get started. Everybody hear me okay?
Yeah.
Okay, good. And I want to thank Anna and I want to thank Peter. I'm actually sitting off in Peachtree Street at Peter's law offices here at Sam Gramble and Russell, or excuse me, Smith Gramble and Russell. And I really want to say thank you very much for letting me use this space today, because as of yesterday, I was at the Georgia Tech Energy Day, and as a double dog, that's kind of hard to actually say that I was there, but I was there. And I actually enjoyed that very much. And I want to thank Georgia Tech for putting on such a great program. And I actually want to highlight some of the things that we're going to talk about on solar today, but I'm also going to highlight something that Georgia Tech has going on next week. So today on our agenda, we're going to discuss real property issues during the life cycle of solar energy projects. We're also going to talk about the solar energy project life cycle, some solar lease considerations for landowners, sale of energy, solar energy power purchase agreements, some takeaways, and just one slide about the energy mix going forward. And again, here's my contact details. Feel free to reach out to me. Just want to highlight this. Actually, I'm flying back to Tulsa tonight, but I will be back next week. I will be back with one of my colleagues in the geoscience department at Tulsa. We will be attending the Gems and Grace workshop April 29th in Macon. It's on critical minerals, which are an important part of solar energy. I mean, you've got to have the base load. And actually, we've been looking at this issue at Tulsa for several years, and it's a small world. One of my high school classmates is helping organizing this, and my thesis professor at Georgia is going to be there. I don't know I presume he knows I'm going to be there because I've registered, but at the same time, Georgia Tech is organizing this. I met the organizer yesterday, and I just want to again thank Georgia Tech for putting that type of event together, because as a result of that, I think we're going to be doing some great things with Georgia Tech and Georgia and Tulsa on our critical minerals research going forward. So again, I know it's hard for a double dog to say that, but a shout out to Georgia Tech for doing such a great event. And next, looking forward to seeing you next week. If you can join us at the GEMS event, it'll be in Macon with Georgia Mining Association, Georgia State, University of Georgia, and others as well. So now moving on to solar energy projects. And actually, that's actually the breakout session I went to yesterday was on solar energy at Georgia Tech Energy Day. And really, we got to get back, like I said, the first time, I'm in professor mode here. The first time we got together in March, I had a saying that we had at Georgia Geological Field School in Colorado, and we were out there. It was called Get High Early. And I don't mean the current Get High that you might think of in Colorado, but really get a high perspective and understand what the energy resource potential is in a location, and then move forward with what you need to do to consider a project going forward in that location. Well, you can see here from the U.S. perspective, really you can do solar even in northern climates. When we took our students last year to Norway, there was a solar energy project in Norway, but in the wintertime, they get just less than 5 hours of sunlight a day. That's really productive. In the summer, they get, probably about 18. So it can be highly variable, but in the south part of the U.S., southern part of the U.S., you can see we have a great potential even in Georgia. And to highlight that, this is a slide I added for our slide deck. And now my family farm is in Johnson County, which is between Macon and Augusta. But I can point out that and I'm going to go into my Georgia dialect here. If you're in Albany, apologize for the northern part of the state, but I think it is called Albany down there. If you go down that part of the state, you'll find that the potential is even greater for solar energy than is even in, say, East Central Georgia, Southeast Georgia, or even in North Georgia. And it's no surprise that you're seeing a lot of excitement in years past. I think one of the biggest obstacles to developing solar energy in Southwest Georgia has been the lack of transmission. But I can tell you, even in my home county of Johnson County, in the last 3 to 4 months, seems like every week I get a call from a solar energy developer wanting to, I guess there's a Georgia Power project that's looking to be developed in our area. And I have a transmission line that goes through my farm. So even now they're looking at potential areas. I mean, Wadley's been a strong area. If you've ever been to Wadley, Georgia, which is in Jefferson County, there's some really interesting projects that have been developed there in the last few years. And you can see they're with the renewable energy, objectives of Savannah and the city of Atlanta. There's a lot of potential growth for these projects going forward in Georgia. So we're going to talk about residential solar, commercial, industrial solar projects, and utility scale solar. And really, a couple of things you're really focused on if you're looking at residential solar. Some of the issues there are like on billing and operations. And on the other side of that, you have to deal with local zoning and homeowners associations and covenants and regulations. And a lot of homeowners may purchase a system directly and put that on their residential accommodation or home. And a third party may come in and install that system on the property. That's actually something we've seen. Some jurisdictions in the country have net metering. Net metering takes place when the system generates more electricity than the homeowner can consume, and therefore that unused electricity goes back into the grid, and the homeowner receives credit for that excess electrical generation from their solar system on their home. However, we have to balance out some of the issues we've had with zoning laws and also the desire to have more solar energy. In fact, California passed a law that has overridden a lot of the homeowner association covenants and basically said that homeowner associations can't block solar development on residential solar. It's more of a situation where the state has passed a statute saying that we really want solar energy in California, and we're not going to let HMAs limit that ability to develop those projects. Now, looking at zoning and the common law, there's a case that we have here from Wisconsin. I'm not going to read the slides, but basically you had a homeowner who had a solar system. This is a case in the early 80s. For his solar system was one for heating hot water, some heat and hot water. And his neighbor was going to build a structure in the neighboring property that was going to obstruct or substantially adversely impact the plaintiff's solar system and cause other damage. And that basically, even though this was the case, the defendant in the case actually went on and started the construction on the structure. The plaintiff filed a complaint seeking an injunction. Basically, the complaint stated the plaintiff was entitled to unrestricted use of the sun and its solar power and demanded judgment, injunctive relief, and damages. The court found that plaintiff had stated a common law private nuisance claim upon which relief could be granted and reverse the trial court's ruling of a summary judgment. Now, as the court pointed out, this legal analysis that Wisconsin had recognized that a landowner doesn't have an absolute right, an unlimited right to use of their land, but they also pointed out that landowners' use of their property could not unreasonably interfere with another person's enjoyment of their property. Otherwise, it would constitute a private nuisance. And this private nuisance doctrine is a non-trespassory invasion of another's interest. Again, you remember trespass, you have to have entry onto another person's property. Here, remember nuisance, it's just substantial impairment of the use and enjoyment of the land, and it can be broadly defined as the common law can do so as any disturbance that impairs that enjoyment of the property. And continuing that discussion, the court pointed out that an easement to light near of or adjacent property cannot be created in the common law at the time, are acquired by prescription, and was not recognized as an easement by implication. The court did highlight that the common law did have to change based on social values and conditions, and the court recognized that the common law is not immutable but flexible and upon its own principles adjusted to various conditions. So you have a situation where the common law has adopted changes from circumstances to recognize certain rights which may not have fitted in that bundle of sticks. Remember, we talked last time, just a reminder of that first course of property law. In the common law, we have that bundle of sticks. Well, one of those bundles of sticks rights, that one of those sticks now may be a certain private nuisance claim that a party can bring in certain jurisdictions when a party impairs their ability to utilize the sun in a way that would be one of substantial interference, i.e. a private nuisance. Now, looking at some of the Georgia solar easement laws, we're actually going to do a survey of Georgia laws here because this is a Georgia solar session. And note that in 1978, to give us some historical context, Anna and Peter and I were talking about political science before we started, and you have to remember what we had. This did not happen in isolation, remember, and this is the fun part about history and poli-sci is that you think back to what happened in the early 70s. You had the Arab oil embargo, you have the Carter administration coming in, and you have a strong push for developing solar energy in the US as a counterbalance to that Arab oil embargo. Well, Georgia acted very similarly with those concerns, and accordingly, Georgia passed the Georgia Solar Easements Act of 1978, which an easement may be established to allow owners of solar energy systems to negotiate for assurance of continued access to sunlight. So this is where Georgia really started down that road of protecting solar energy development. And again, as it says, any easement must be created in writing as subject to the same requirements of all other legal easements, as it says in the statute, description of the airspace affected by the easement and any terms and/or conditions which the easement is granted are terminated. Here's the authority for that particular Georgia statute. Moving forward a few years, you had the governor sign into law the Georgia Power, that was a Freudian slip, wasn't it? A Georgia Solar Power Free Market Financing Act of 2015, really to promote Georgia as the first state in the US to basically approve private sales of electricity from on-site solar systems. You also have the statutes, the sections here cited that I've provided for you. Again, it's really one of those areas that Georgia took a very important or giant step into promoting solar energy development here in the state. And this is continuing some of the discussions of those various sections in that statute. And again, it's also important to note that Governor Kemp has also signed House Bill 300, which also amended the Solar Power Free Marketing Act of 2015 by adding decommissioning requirements that must be included in the solar power facility agreement requirements to provide solar assurance and to ensure such requirements are fulfilled. In fact, this is just to stop here on this for a second. This is one of those tales that I use when I'm on the farm in Georgia or anywhere in Oklahoma, or when a farmer comes up to me and says, Buford, solar company's coming to me. What do I need to do? I said, well, look, I'm not your attorney in this case. I'm not here to take your money, because we need to know basically right off the bat if they're really serious. And what's one of the things you can do is basically, this is even before this became statute, I always would tell people that make sure that they can post some type of financial security or or bond or something that's liquid, whether it's insurance, some type of financial instrument that has liquidity that you can draw on to cover the decommissioning and abandonment reclamation of the solar project. And if they can't do that at a level similar to what the federal government requires, for example, on BLM land, because before you put any solar project on federal land, for example, Bureau of Land Management land, you will have to post financial security of a certain amount before you break ground. I know a lot of the leases I've seen require that some of the solar developers provide that security after so many years. No. One of the first things I say is it's got to be before you break ground. And so this is a step forward, I think, just to highlight, you can see this is a passion for me. This is one of those things that it applies not only to the solar, I mean, it applies to oil and gas, wind. If you're going to do anything on federal land, you're going to have to post some type of security. And I just think I've always tell landowners, whether they're in Georgia, Oklahoma, or Louisiana, Texas, the 4 jurisdictions I'm licensed, that you need to make sure that this is something people that are talking to you can do. Otherwise, there's really not much need in discussing anything else. This is just more discussion of that. In addition, we also have some other things going on with the distribution of electricity. This particular statute was provided, as it says, to provide for required provisions of solar power facility agreements to relative to responsibilities of grantees and decommission certain power equipment. This citation, you can find it at Article 1, Chapter 3 of Title 46 of the Official Code of Georgia. In addition, we're highlighting the various aspects of the remedies for financial assurance. And that's really what we call it, is financial assurance for required decommissioning activities, and also to provide for related matters such as repealing any conflicting laws that might contradict this financial insurance requirement. We have some laws in the 2025 session. I was talking yesterday with some of my friends at the Georgia Tech sessions, and this one actually came up. Leave it to a Georgia Tech engineer to bring this one up to me. No surprise. This is actually one that I already had in my slides, but it's also important thing to think about if you have a farm like I do in Georgia. Actually, the farm I have is under a conservation use value assessment. It lowers my tax rate on my farm. One of the things that happens if you put solar energy equipment or do a solar development on your project, that under current Georgia law, you can lose that conservation status. Now, depending on how your agreement is drafted, the solar developer could pick up. Actually, they should, if it's reviewed properly, any lease that you have your client sign should require that, especially if you're representing the landowner. And I would argue, even if you're representing the developer, this is a reasonable thing to do in your standards, is to say, look, if we're putting solar equipment on the farm, we should pick up the increase in the tax, the ad valorem tax evaluations. And also, if you're going to lose your conservation status, that should also be in the agreement. But this bill basically says that, and again, the tech individual graduate had asked me, what's the status? I know the legislative session here in Georgia is ending pretty soon. I don't know what the final status of this bill is, but this is one I think probably should move forward at least I would hope it would move forward and get passed and signed by the governor. But really, I think it's critical that if you're going to put a solar facility on a farm, that conservation and use value assessment should not go away. Basically, those assessments offer reduced property taxes for a 10-year period for the agriculture and forestry purposes. This is something I have to justify on my farm in Johnson County. And I think just because if I were to put a solar farm on there, I don't think that would be something that I should lose the conservation use and value assessment. Again, that's one of those bills that I think would be very practical and useful for the Georgia legislature to move forward and the governor to sign. You also have another bill that's what happens if a solar facility closes. This is House Bill 249. It's basically designed to tack on more regulations related to House Bill 300 last year. This bill requires solar developers to have enough financial assurance to decommission a solar facility once it needs to be closed. And this is one of those things I'm very passionate about, making sure that land gets reclaimed, not just have a situation where you have a insolvent solar developer and you have a facility that's sitting there idle on land that needs to be decommissioned. The facility needs to be decommissioned and the land needs to be reclaimed for other purposes. In addition, have a bill, House Bill 320, recycling solar panels in Georgia. If passed, House Bill 320 would require solar panels to be recycled instead of thrown in landfills. This bill places the responsibility on solar facility owners and operators, with fines as a consequence for not following the rules. And as is the fine, you could be up to $1,000 offense, and the prosecution could be from the Attorney General or the District Attorney otherwise. And then renting solar panels. If passed, House Bill 5007 would allow community solar projects owned and operated by Georgia businesses to offer clean, low-cost energy to Georgia Power customers through a subscription process. It's basically comparable to renting a solar panel in a shared array. And it's really involving small-scale solar, 5 megawatts on 25 acres or less. Continuing our discussion about zoning and homeowners associations, really you're looking at, you got to pick the location, you got to pick the spot in applicable zoning law, and look at any covenants or restrictions of record that may apply. This is really important to know. I've had solar developers and trying to do projects in Tulsa. By the way, Oklahoma does not have the model zoning statute, solar zoning statute that I'm going to cite in a minute. But Georgia's way ahead in that game. But a situation in Oklahoma that's very normal, or generally happens quite a bit, where a homeowner will go to a solar developer that can put residential solar on their house, but it's the aesthetics. Some of the developers, homeowners associations have actually rebuffed or said you can't do that. That is one of those architectural. If you've ever lived in a development that has had a homeowners association architectural review board or committee, those can be somewhat onerous, but I think there's more over time, we're seeing more these HOAs being more receptive to solar development, especially in states like Georgia, maybe not so much in states like Oklahoma. Like I said, California is one of the states that has enacted solar access laws prohibiting an HOA from a blanket prohibition. However, they can put some reasonable restriction on the placement of the solar installation. In other words, don't put the solar facility or installation in the front yard, maybe on the roof where it's more aesthetically pleasing, or possibly in the backyard or something like that. But there are some reasonable restrictions on the placement of these solar facilities on residential units. Now moving to commercial, you have generally less complexity when the owner occupies the realty. It can be somewhat more complex when you have co-ownership, but again, solar projects and commercial industrial projects are definitely going to be subject to local zoning, and also any covenant restrictions that may apply to the property. Again, the most complexities arrive when you don't just have the owner of the facility looking to put the solar, but you have a tenant or some type of concurrent ownership. Those additional approvals can add to the complexities of the solar system that you're trying to do. Again, another thing is that these commercial and industrial installations tend to be on brownfields, and I've put in a definition of brownfields. Most of my practice has been on brownfields when it comes to energy projects, because a lot of these are industrial areas, commercial areas, even ports that I've worked on. They're all pretty much brownfields. And basically, a brownfield is basically a location that has been previously utilized for some industrial or commercial purpose, and it's being repurposed for a different type of use. One of the things I strongly recommend, I do not have it in my slide here, but if you're going to go in to a brownfield and you're going to repurpose it, I always recommend, for my geological background, some type of background, do some type of coring, some type of environmental assessment, determine what type of substances pollutants might be present, because you want to have some type of baseline so that if something is discovered later, well, it's not something that we put there, right? It was already there. So you want to make sure you've got that captured when you go into brownfield situations. Often the utility scale don't go in, or not utility scale solar projects are not usually in brownfields, or they are actually more likely to be in some type of greenfield, which we'll see in a second. These large scale energy projects still require extensive due diligence, a lot of moving parts, but a lot of times these utility scale projects are on what we call greenfields. A greenfield is an undeveloped piece of land, generally farms, ranches, state and federal land. You again have to be careful, as with wind farms, developers, solar farms require management of numerous and complex real estate matters. And the real estate discussion, we're going to talk about real covenants, but really there's a lot more we could spend the time with the real property section discussing a lot of these real estate issues that go along with any type of any energy project. And I want to highlight something I mentioned briefly was the Georgia's Model Solar Ordinance. I did not get to participate in this at the time. This is a joint effort between Georgia, Emory, Georgia Tech, and others. Georgia is one of the states that had the foresight to create a Georgia Model Solar Ordinance that provides county and city officials and other decision makers access to best practices and a common baseline. It's a comprehensive document that covers multiple scales and types of solar energy systems that the cities and counties here in the state of Georgia can use to adopt. And actually, I've proposed that Oklahoma adopt some of these. And I've got the reference there. I was able to talk to Professor Richard Simmons yesterday at Georgia Tech Energy Day, and he wanted me to pass on that actually they're about to revise. They've got some data. Of course, engineers have data. They got some data now, and they're going to do a remake or revision to the Georgia Model Solar Ordinance. So I'm looking forward to seeing what comes out of that. That's in the near future. So that's actually something else I got out of the Georgia Tech Energy Days. Now, actually, this is not a solar farm on my farm in Johnson County, but it's not far away from my farm. What's interesting about this is a location that was going to be a biofuels facility right next to a biofuels facility in 2008. It's across from the prison there in Johnson County. And now it is a solar farm. So something that was going to be a solar or biofuels facility, or it's less than a couple hundred yards from that facility, now is a solar farm. It's amazing how the same locations can fit different projects based on the economics. So what was when crude oil was around $150 a barrel in 2007, 2008. I think it was 2007, if I remember the date. I know it was in July. But the point being, the same general location can be repurposed for another type of facility based on the economics, which fit more with solar energy development now in the current economic climate. Now, if you're going to do this is more looking at the project. When it comes to solar energy, you got to look at guarantees of title when it comes to the lease. In fact, the last proposal I got last week, and I'll give you some of the economics. It doesn't hurt to discuss the economics. The proposal I got, I'm not going to mention the company, was an outright purchase of $1,000 an acre, or a lease during the lease period of $1,000. No, excuse me, let me take that back. I misspoke. It's an outright purchase of the land of $10,000 an acre, or a lease of the land at $1,000 an acre. So, of course, that company's having to do we're not going to do that project, but the point being that hopefully they've done their due diligence on the ownership. I'm not going to the ownership structure of my farm, but if you're doing a solar energy project, before you make those types of offers, you're going to have to guarantee the title that you're going to make that offer to the other party. Now, one of the things I will give a comment on when I advise my landowner clients, I do not recommend that they provide guarantees of title, because I know what the developers are doing. There's not a bank in this country or a financing institution in this country that's going to give you the capital for investing on a solar project if you've not done your title work. So what I tell my clients is, why pay for title examination twice? Why should my client guarantee title? We'll quick claim it. Basically we'll release if you're selling it. It'll be a quick claim, but we're not going to provide a basic full guarantee of title, not even a special warranty guarantee. It's basically, it's one of those things that if you're the developer, you're probably wanting the landowner to provide some type of guarantee of title. But my view is, because I tend to represent landowners and I know what I worked in-house, I know what the title examination work from an in-house company is going to do. They're going to do that title examination anyway. So you got to discuss with your own clients what's best in that given situation, but be careful when you're advising, whether you're on the client side, that's the developer, or your client side is the landowner, how much guarantee of title you want to give in that agreement. And then it comes to long-term commitments. You generally see two phases. You see the option, which an option agreement to cover the site evaluation, the bids. For example, on my farm in Georgia, I'll give you an example. Most of the developers are looking at my property there are wanting an option on the full farm, which is not something I'm willing to give. That's something you have to advise your clients, there are certain areas that they're willing to give an option on versus an entire farm. An option means they can, by the way, but whether it's the option agreement or the sole lease, be cognizant, this is more of a real property issue, be cognizant of the public records requirements in filing. If you're the developer, you still need to file the option, some type of, short and abstract version of the option, file that in the appropriate land records office. Otherwise, you're may not have the benefits of notice to the public. Same thing on the lease. Once the developer decides to move forward the lease, then basically there's some type of often you'll see a basic rent payment with no royalty payment or benefit of the renewable energy credits. And this is something I often push for when I'm advising my landowner clients, is you need some upside on those solar leases, not just a basic rent payment. There should be some type of royalty payment based on generation, and also some type of renewable energy or carbon credit benefit. Because the developers, I can promise you, one of the benefits of this is not the full subject of our class, but one of the benefits of the Inflation Reduction Act is that you can monetize those credits and sell them to parties that have third-party tax liability. Boy, we could do a whole session just on that. Going back to title examination, often those examinations are under the standards of American Land Title standards. And like I said, you're going to have to do that before you get financing. This is a really important topic. I've got a lot of slides here, but we're not going to, I may cut some of them out, but this is important in the sense that real covenants. And this applies to not just solar energy projects, it applies to all energy projects. You can do things in real covenants that you can't do in contract law, okay? Real covenants run with the land. The land is benefited or burdened even if the parties that created the covenant no longer own the land, and it permits transfers or rights or duties generally not permitted by contract law. Just to remind you that real covenants, purchaser of the land encumbered by a covenant is bound even if he or she did not agree to that covenant, while a contract law would require to agree to the burden. Looking at the language, this is not exact, but real covenants usually use promissory language like I promise or I agree, compared to easements use conveyancing language like I grant or I reserve. Real covenants, this is important. Real covenants are legally enforceable. The key is the intent for the covenant to run with the land. That is critical. Touches the concerns of land. We're not going to get into too much. We'll talk briefly about privity of the state, but really what I want to focus on is that the covenant really has changed over time. It used to have to be executed under seal, but now if there's consideration given, most states require some type of writing. Again, if the covenant is conveyed by a deed, it can be enforceable if the grantee accepted even without the grantee's signature. Again, the original covenanter, make sure we remember our terminology. You have a covenanter, that's the person granting, and the covenantee must intend that the covenant run with the land. There's no particular manner to manifest that intent. This goes back to an old English case, the Spencer's case in 1583. And in touching the land, it must affect the nature, quality, and value of the land. Commonly understood to require an increase or decrease one of the parties legal obligations of the land, and the covenant must affect the value or ownership of the land. These are the cases. If you get nothing out of my lecture today besides the points about financial assurance, I encourage you to go through these cases. I'm going to walk you through the one at the bottom, which is the first one. I was a professor at TU. I just gotten hired in 2015 from INE, and I'm sitting in my office at TU, and I get a call. Phone rings, and I pick it up, and it's a reporter calling me up. And as we all do, it's like, Professor Pollitt, I know you know about the Sabine case, and of course, what do? Google it. And what this case is, you had a midstream company, think, a company that's transporting petroleum. And remember in 2016, if you remember the economics of the time, crude oil about a year or so earlier in 2014, 2015 had been over $100 a barrel. Now it's probably, I can't remember the number, but it's probably 50, 60 at the most, somewhere maybe less. Substantial price drops. So a lot of the frackers were going into bankruptcy. And this is a bankruptcy case. And the midstream company was arguing, as I pulled up in the case, and the reporter's asking me the question, is the midstream contract of transporting the petroleum, is it a contract that can be pulled out of the bankruptcy? Because the midstream company was arguing that their contract was a real covenant with the land. And I thought about it just for a second, and I had to handle, when I was in-house at Technique, the Enron case. And I had, as a baby lawyer, you get handed those kind of cases. And I looked at it, and I was like, this is an executory contract. And if you remember executory contracts, this is the benefit of being in-house counsel, I guess. Executory contracts are contracts that are continuing performance. Okay, if I'm delivering a product to you, like phones, and I've already delivered, it's not an executory project before your bankruptcy. It's already performed. I've delivered the phones. You've got them. Performance is completed. Okay. But a transport of crude or petroleum is an executory contract. And actually, the court agreed with my understanding, my thought process. The midstream companies were not very happy about the ruling in Sabine, because the court said that there was no burden of the land. If you look at the line of cases here, you'll see it kind of goes back and forth. But I can tell you, even when my discussions with Gable Gotwells, the one that you'll find is there was a case in the list here where there was a dedication of reserves from the developer, the operator, for transporting the petroleum to the midstream company. That dedication of reserves in the ground created a real covenant. It burdened the land. So my advice to you on solar is that if you're going to create a real covenant, it's going to have to create some real right or benefit a burden in the land. It's just, otherwise it's just going to be a lease. Okay, where you're not going to have the benefits of a real covenant. You've got to either, the covenanter and the covenantee are going to have to either create some benefit or burden in the land. Otherwise, it's not going to be a real covenant. And therefore, those agreements can be brought into bankruptcy court. Anyway, that's another reason why you need financial assurance, right? Okay, so conveying land subject to a solar lease. Solar energy developers must want to lease the run with the land. I'm seeing this more and more in the leases I see. They must bind the lessor, heirs, and successors and assignees. But even then, if you use the wording, I still think you need to create some type of interest in the land. When it comes to these type of topics, purchase of land subject to a solar lease may be bound to the terms, even without specific reference to a solar lease. This is really, we're talking about notice. If I'm buying land, this is the point about filing the option and the lease in the public records, then that's constructive notice. If there's solar panels on the farm and I'm buying the land, that's what we call inquiry notice. Maybe I should go find out who owns those solar panels, right? I'm not going to go through this, but this is really the traditional common law rule of bona fide purchaser. This is more of a real property discussion. I'm going to park this for now. You got it in the slides. Well, I really want to get to the solar energy project life cycle, negotiations and acquisition, evaluation and bid, execution of the lease, construction and installation, operation and maintenance, decommissioning and reclamation are all elements of this life cycle. Impacts on uses of the land, farm practices, hunting, timber, minerals. Oh, one of my friends who's a land person sent me a text of a timber lease. Some of you are working on timber leases and things like that. Listed probably 20, 30 minerals. I've never seen a timber lease list 20 or 30 minerals. I could not believe how many minerals were listed in this timber lease the other day. It was really amazing what's happening in Georgia. But if you've got solar development, you may not want someone to come on and start developing minerals, because that dust can, I mean, timber, remember we talked about shadows, you know, timber can impact the amount of sun that the solar farm gets. Hunting, bullets and solar panels often don't react very well. Well, I think that quote, I'm paraphrasing from The Hunt Red October, but there may be limitations if you've got a hunting lease. And then farm practices, especially with battery storage, some of the battery storage agreements I've looked at have limited the amount of row cropping near the storage facilities. Dust and these type of developments don't always work. So be careful about, when you're looking at these leases, about the impacts on adjacent land, and also tax valuations, which we've already talked about. Also, easements, you know, you can have affirmative easements, negative easements, and also developers often want to grant a mortgage with the ability of financial institutions to take over in case of default. When I'm reviewing for the landowner, I generally remove the mortgage language. I generally represent people that have generational interest in their land. Why would I want them to grant a mortgage? But if I'm the bank I'm probably going to want some type of more substantial security. I've talked to the financial people such as Seminole down in Florida that help finance these projects. There's language that can be used short of a mortgage that will make the financial community, financial institutions happy. I think you can go short of a mortgage, but again, most developers want a mortgage granted on these solar leases. Confidentiality, these are basic concepts. I'm not going to go through all these. Liability, dispute resolution. Just make sure you cover form selection, attorney's fees, litigation fees. These are all important to any energy contract, not just solar. Again, mitigation tools. I'm very adamant. You can tell passionate about financial security from the developer in case of insolvency, and also insurance to cover the risks. I mean, for example, even when I have hunters that come on my property for the hunting lease, I mean, they provide insurance. Make sure that if you've got your solar developer coming on, it's the same thing. They should provide the third-party liability, the auto, the full spectrum of insurances that go just like you would do if this is a construction section. I mean, if you're doing an EPCI contract, I mean, think of the full spectrum of insurance that you would expect to see on those projects and levels, including the umbrella policies. We could do a whole session just on insurance on these projects. Securitization is something we're seeing. We're also seeing bundling of receivables to help finance these projects and selling that to investors for securities. Again, guarantees of title, we've already talked about. I'm going through. Sorry about that. Let me get a couple of things. Power purchase agreements. These are the various aspects of the power PPA. Make sure you cover all these aspects. When it comes to PPAs, the seller is generally a single purpose entity owning the solar farm assets. Often these are single LLCs, like Johnson County Solar Farm LLC. You'll have a buyer, say energy trading subsidiary, some type of industry sector participant or local government. But also you need to be cognizant of the financial health of the parties and also the financial security provided. Output agreements, you may have some type of energy purchase as measured at the meter of the delivery point. Also, just like with the landowner, you're going to be wanting to be concerned under the PPA about the renewable energy tax credits and any future environmental credits, carbon credits, which depending on what this Congress and this president do may vary, but at least still be cognizant of those when you're drafting. Again, advertising, you have Fair Trade Commission concerns, and then similar to oil and gas, you may have, some type of pay a contract. Either you take the power or you pay accordingly. And it's also the purchase of output actually delivered, plus the impact on the party's responsibility for transmission. And then price regulated, is it peak or off peak, and changes to the market? Do you remember changes to market conditions are generally not force majeure under the common law? And then note, this is something I learned from my EPCI days at Technique. Remember, with the force majeure, you get extra time, but not additional compensation. If you want extra money, you're going to have to pull that out of the force majeure and put some type of compensation schedule. And then the delivery point is often at a meter location, and an interconnect between the solar farm and electrical grid and transmission service may be needed to get the energy to the delivery point. Guarantees, again, focused on the amount of energy produced, the startup challenges, desire for certainty, and banking. Can you bank overproduction or not? And that's something we've seen in other energy sectors. You can often bank time and to help mitigate periods, but if I'm the buyer, I may not want to be able to give the developer or the operator that ability to bank overproduction, because I'm going to be able to sell it. And there's a required bandwidth. There's like a financial incentive, some type of LDs. Maybe if you go beyond outside that bandwidth, think about some type of liquid debt. It may be also a discounted price or underproduction. There might be a purchase and transfer energy and the renewable energy credits to the buyer. And again, I highlighted liquidated damages. And as we all know, under the common law and also some cases, even statutes, that LDs cannot be as a penalty. They have to be stipulated, but they have to be reasonable anticipation of actual damages. And when it comes to PPAs, is it a long enough time to secure financing and satisfy investors? At the same time, the buyer may want to adjust and have flexibility to adjust to market conditions. And what do you do about early termination and options to extend? And a default, what are your trigger events? What events can trigger default? How do you calculate damages? And as at least the way I see things, I think most times you have some type of limitation of liabilities and remedies, whether that's exclusively stipulated in the contract, all other remedies are excluded, or if you have some type of cap on damages. If you're in the EPCI world, I know you know these terms, but if you don't, it's one of those things. At least when I was at Technique, when I started from the contractor side, this was one of the areas I spent a lot of time on, was those, not only the events of default, calculation of damages, but how could I limit my liability as a contractor to the developer in those situations. And again, changes in law, financial security, dispute resolution, governing law, and applicable law, all are points that you've been aware of. And then looking at hedging agreements, you have financial instrument or financial institutions doing that. Basically, it could be a trading desk that's doing that. Basically, the price is often correlated to published market conditions, whether current or future, such as natural gas prices. And again, these financial PPAs are going to be subject to due diligence, often posting security by the developer to lock in price. And there's often a lien position with regards to certain collateral. And here's some references here. And then some takeaways, just as we wrap it up. Make sure you're doing fine time for questions. The parties to solar energy leases and power purchase agreements need to understand the complexities of these agreements, especially the impacts on the land. And landowners considering solar energy projects on their land should consult appropriate tax, accounting, finance, and also lawyers, because we want to be called to. And this is the last bullet point, but this is that visualization skill that I talk about constantly, being able to visualize anticipated changes in use of land. I generally try to advise clients, whether I was in-house or even now when I'm teach or when I'm in my firm, basically, whatever you sign with another party, make sure that you're not limiting yourself or your client's ability to fully utilize the land for other things that no party's anticipating at the time. And this goes back to consideration. The consideration paid under the agreement should be what is foreseeable, okay? Don't give away all the golden jewels, the golden eggs for things that you can't anticipate. Because that's me, that's not this consideration discussed and exchanged. The benefit of the bargain, let's take it back to our contract rule. The full benefit of the bargain should be what we can fully anticipate now. Okay. If you're trying to cover future things, then as I would say, that's an additional discussion with an additional price point. Questions?
So I actually have a question, Avery Marin. First, actually a comment. You mentioned doing this, you could do a whole hour just on insurance coverage. I personally would sign up for that because it's something that I think would be very useful. My question for you is something that represents contractors who do installs for commercial solar facilities. And we've had some developer clients who've had the onerous supply chain language. And I'm not talking about tariffs. I'm talking more about where the products are coming from. And they'll have the language that you can't source materials from certain countries or certain parts of countries, like the products that might be made by the Uyghurs in China, for example. And the client will tell me, Avery, we're buying the products from China. We have no way of knowing where the companies we're buying from are actually sourcing their, components for the solar panels from. And we could call them up, we could have them indemnify us, all these things, but we can't conclusively certify this. How have you addressed situations like that in the past?
Well, actually, I came up when I was in Qatar, and I was representing McDermott at the time as legal director, and I was dealing with Exxon. And if you remember Dodd-Frank, do you remember Dodd-Frank? It had some onerous language in there about tracking the full supply chain when it comes to, they were focused on not just oil and gas, but also gemstones, diamonds, and things like that. And I was having to sit in front of Exxon, and they were actually struggling with the same issue, but I had to put in the language I had to put in as I could not fully certify, because we had, as McDermott, we were the contractor, but we were sourcing equipment from, especially as I tell people, as you go from domestic to international suppliers, you actually increase your complexities tremendously. I could not, because of applicable law, this is how I'd phrase it. Applicable law, I cannot guarantee that another jurisdiction where these suppliers are working are going to be as stringent as what we have in this particular situation that I'm negotiating. Now, what I will tell you is that when it comes to boycotts, that you got to be careful of those as well. But when it comes to language that what I put in that particular agreement with Exxon was this is how I drafted. I said I will fully comply with U.S. law. Okay, but beyond that, I could not comply with something that is a corporate directive. Does that make sense? And so, and that's how I sold it to Exxon. In fact, Exxon was happy with that. Fortunately for me, the Dodd-Frank rules regarding that went away. But the point being is, I couldn't get it goes back to governing law versus applicable law. And the language I used was, I will fully comply with U.S. law. Full stop, no more, no less. And if the federal government's making me do this, I will do it. But if the U.S. government is not requiring me to do it, guess what? We're not doing it. And so that's the way I would do it. This is how I'd phrase it the other way. If they want me to do that, I'm going to go back to my favorite language I love to do. There's a cost impact. Okay. That goes back to my first mentor. My first boss said, you find solutions. You don't tell people no. Just go to your expert. And what's the number? Here's the cost impact.
Okay, that's good. Thank you.
But no,
you forgot the question.
Sure.
Hey, good to see you yesterday at Georgia Tech Energy Day.
Thanks.
Yeah, so the House bills that you mentioned, the proposals that you mentioned early in the presentation, I'm wondering, what is the potential of those being passed, and how much support are they getting from, perhaps Georgia Power, the state EMCs, Georgia Solar Energy Association? I mean, what's being done to get those passed as as highly probable as possible.
And this is my friend Mark that I've known for years asking me this question. This is a tech grad putting a Georgia grad on, asking him to do his homework. And this is where I'm going to answer you. I'll give you my best answer. I honestly can't tell you how much pressure is being put on. I would hope that people like that represent the farmers, I'm not going to mention any names, would be pushing this pretty heavily, but I can't say that they are. But I think that if it's one of those things that I think the conservation stipulation is something that if you really, because not every farmer has a law degree, right? I mean, I got some friends that are very sophisticated, more sophisticated farmers than I'll ever be. My father's the most sophisticated person I've ever known. He had a high school education. But the point being is they can't always know the statutes or the tax laws. And I would hope that that the advocates for farmers and landowners would push for that legislative proposal, because losing a conservation certification or assessment evaluation based on putting a solar farm, I mean, just for example, I get a substantial reduction on my farm in Johnson County because we have bona fide agriculture practices, hay grazing, hay production, other things, growing timber. And
Right.
if I put a solar farm, that would more than double my wife would be basically, no, you're going to have to work a lot more overtime. You're going to have to charge a lot more clients than you're doing to pay that tax bill. And so, yeah, it's one of those things. I can't give you the exact status of it, but I think it would, if anybody's on the call that can help facilitate that, I think that's one of those things that is common sense legislation. I mean, because the farmer's not really benefiting per se. They're getting rent and they're getting payments, but I'm saying it's not an industrial. That's not it isn't. This is one of those things I'm kind of beating around the bush, but when there's 3 slides I use when I introduce to my students supply chain. I do a supply chain lecture, and I show basically that oil and gas is like an industrial activity. And I think what the viewpoint is, solar farms tend to be an industrial activity. And I think what we're doing by not having that conservation preservation is we're still treating that farm site not as a farm, but as an industrial activity, and we're taxing it accordingly. Well, the farmer's not getting that. I mean, I can't put timber there, but at the same time, there's a benefit to the environment. And my view is that the benefit of the environment that you're getting should be viewed as not as an industrial activity, but a conservation activity.
Right, I agree.
But
Thank you,
I can't
Robert.
apologize, Mark. Does anybody on the call know the status? I actually haven't looked at to see since I put together the slides last month what the status is, but anybody know? No. I guess I'm
No,
not that far.
Buford. Hi,
Yes.
Chanel Chevy Maldonado. I listed a comment in the chat. What I
Sure.
will do is actually email it to you because I realize we have just 2 minutes remaining.
Sure. Let me look at it though right quick as well. So any other questions right quick before we wrap up? Well, listen, by the way, before we wrap up, I will be, God willing, the creek don't rise. I'll be, not only we have the session in May, but I also plan on being at this, I've already reserved my hotel at the state bar meeting. So hope to see you not only next week in Macon, but online next time we're together, and not in June.
Yeah, Buford, just had a quick question. On this topic of conservation land impacts, there is there's a new push for something called agrivoltaics, which is
Oh.
making photovoltaic units more complementary to existing ag operations by raising panel height to allow more sunlight and allowing grazing and cropland under the panels. What can you tell us about that? And is that
Oh.
something that you're seeing more in Georgia?
Yeah, about Georgia, but I've seen Oklahoma. I have a professor that was putting together a DOE grant for agrivoltaics in Oklahoma, and I was on the proposal with them. So it is a hot topic. Actually, the only reason that my colleague pulled, because I was going to do the legal and regulatory work for the project, the only reason that we pulled that, I chose not to pull the proposal, was because of the current uncertainty about this administration and funding for that project. I think there's a lot of opportunity with agrivoltaics. I know that I've got research colleagues at OU that are, not OU, I can't believe I just said that, at University of Tulsa, that are all behind agrivoltaics and have some great research projects. It's just a question of what's going to happen with the grant, the financial incentives, and the view of this administration of agrivoltaics. But I think it's a great area. I'm interested in it. There's research. If you're interested in the topic, email me, because I know there's a lot of people that I'm working with that are interested in the topic as well.
Thank you.
No problem. And I'd love to see it in Georgia, by the way. I mean, by the way, if you're ever driven in South Georgia, don't just drive 75 to Florida. You'll see olive farms down there. Can you believe we actually got olives down in South Georgia? I feel like I'm back in Italy. We got a lot of stuff going on here that's really exciting.
All right, Professor, I think we've reached the end of our time, so I'd like to thank you again for making this presentation today, putting it on. We will see you in about a month. I think next time we're doing some stuff on carbon, if I'm not mistaken.
Yes,
So that should be pretty interesting.
it's an exciting time.
If you're interested, the Energy Law section has a wine tasting next week. So if you haven't signed up for it, please consider doing so. Should be a great time to be had by all. All right. Well, thank you very much, and we look forward to seeing everybody next month.
Take care. Bye. Thanks,
you.
Peter. Thanks, Anna. Thanks, everybody.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining and have a great afternoon.